What if a property owner says that they did not know about the dangerous condition that caused your injury? In a premises liability case, property owners sometimes argue that they were not aware of the dangerous condition that causes a person's injury. Under North Carolina law, a property owner is not automatically responsible for every accident that occurs on their property. In many cases, the key issue is whether the owner knew or reasonably should have known about the dangerous condition. For example, if a hazard existed long enough that the property owner should have discovered it through reasonable inspection or maintenance, then it can become an important issue in the legal case. Evidence such as medical records, incident reports, photographs, and witness statements often play a pivotal role in evaluating whether or not a condition should have been discovered. When a property owner claims that they did not know about a hazard, the case often focuses on whether the condition existed long enough or was obvious enough that it should have been addressed.